that at least one issue we should be thinking about is what our peer nations do. And it's not the most important factor. It may not be even in the top 3 or 4. But if we can identify in our regime something that is distinctive and we can't find an explanation for that, or we can't find a good explanation for that, that ought to be worthy of comment as citizens, it seems to me. So on that basis, Anderson, in his review, had a bit of a stab. And he introduced his bit of a stab with these rather troubling caveats. He said, look, first of all, this is awfully complicated. Pete's mentioned some of the other UK statutes. Anderson identifies 65 other statutory powers outside of RIPA that give government the right to access comms data or content. 65. And some of those are pretty surprising. For example, Section 16 of the Gangmasters Licensing Act, 2004, the Timeshare Act of 1992, the Animal Health Act of 1981. Whose communications were they going to look at for the Animal Health Act? What were they expecting to find? A very wide-ranging set of powers, and some of them are pretty surprising, even after the repeal that took place of a number of those powers in 2012. So that's the first thing, very complex. And it's not just the UK that's complex. When we look at the French regime, you're looking at 8 or 9 different pieces of statute that overlap to some extent, all passed at different times. In the US, you're looking at ECPA and the statutory amendments ECPA has affected, Electronic Communications Privacy Act, you're looking at FISA, you're looking at executive orders. Again, that regime has been amended. You're looking at a very complicated web of legislation. That's the first caveat Anderson gives. The second, he says, is the words on the page only give you part of the story. Some of this legislation is very old. RIPA's 15 years old. Some of the US legislation is more than 30 years old. So it contemplates a world really different from the one that we use today. And as a result, its application to the world as it is today is a little bit wobbly. Let's put it like that. A little bit wobbly. So in order to really get to grips with this stuff, you've got to have some practical understanding, and that's very challenging. And as a result, Anderson really wrestles with this. Out of that 400 pages of his report, there are about 20 looking at international comparisons, and he looks only at the Five Eyes jurisdictions in any detail. So Canada, US, Australia, New Zealand, that's it. That is a pretty trivial comparison by comparison with the rest of the report, which is an exceptional piece of work. This is the one area where I certainly think the report struggles. And that's one of the things that motivated us to have a stab at this. Look, we have a lot of this material, and we thought we'd try and bring it to bear. Now, the most rational way to do this would be to compare the UK regime against the G20. You know, if you're looking at international peers, that would be where you would sit. Regretfully, we don't have details for all of the G20. So we have resurrected the G8, an organisation that no longer exists, not least because Russia is no longer regarded as an acceptable part of the international community. So we've resurrected the G8, and we've added India to create a kind of fantasy G9. Actually, there is rationale. India has a very, very unusual surveillance regime. So it is worth including in this sample size. That's the first thing. Clearly, all of the caveats that Anderson has made apply equally to the work that we have done. Certainly, the latter part, you know, we have practical understanding of the way this stuff is implemented in a number of the jurisdictions you'll see, either us or our partner firms, but not all. In some cases, probably no outside counsel does, because it's not being done by telecoms authorities, telecoms providers. So we're also going to look then at the same categories that Pete talked about. So we'll look at who has the power, what purposes can they use this power for, how is it authorised, and then we'll have a stab at volume, and volume is really tricky. So who has surveillance powers generally? And for each of these slides, left-hand side will deal with interception. That's the wiretapping. What's the content of the envelope in old world technology? And on the right-hand side, you'll see comms data. What's on the outside of the envelope? Traffic data, location data, maybe some parts of URLs if you're thinking carefully about it. That'll be on the right-hand side of the slide. Agencies, that's security services, so SIS, SS, GCHQ, LEA, not local education authorities, but law enforcement. And if you look at the left-hand side, intercept, who has these surveillance powers? To find any clear distinction between this sample, you'd need to work quite hard in public administrative law. We certainly couldn't discern any significant differences on the left-hand side of the slide. On the right-hand side of the slide, as Pete has already alluded to, you see a wider range of authorities that get access in almost all of these jurisdictions. The UK regime, because of the way it works in relation to comms data, because it allows internal authorization, gives that access right to many more authorities than we could find almost anywhere else, And when you start to unpack that, and Anderson does in his report, more than 600 a lot of those are local authorities, nearly 300, 170 of those local authorities have never used this power. So we have given local authorities this power, and the vast majority never use it. And for those that do, some really odd things start to happen. So I'll give you a little bit of free information. So the London Borough of Newham, very poor part of the UK, used this power 34 times last year. Newham's got a population of about 350,000 people. Glasgow City Council. Glasgow City Council, second biggest city in the United Kingdom, population of more than 1 million. Who thinks Glasgow City Council used this power more than London Borough of Newham? Hands up. You're all a very knowledgeable crew, aren't you? Okay, so everyone put their hands up, because we're going to go down. Everyone put your hand up. Right, keep your hand up if you think the London Borough of Newham used this power, the Glasgow City Council used this power less than half as often as the London Borough of Newham, so less than 17 times last year. Less than 17, okay, so 2/3, I'd say, still up. Who thinks Glasgow City Council used it less than 5 times? City of 1.2 million people. About a third. Who thinks less than twice? Yeah, well done, Gail. Once. A city of 1.2 million people used this power once last year. That I certainly think is worthy of comment.